Good afternoon, everybody. This is Marty from Dog's Blog. In the noontime report of the Frank Carson et al. Trial on October 18th, 2018. Jury was scheduled to come in at 11 o'clock this morning. They had to finish up some of these motions. She did rule on the mistrial motion. And so we were scheduled at 9 o'clock. Judge got on the bench around 9:14. They initially started talking about the expert testimony and the path of the bullets, and Marlissa Ferrer had stated to the court she was not able to get the experts here on such notice that she was trying to do it yesterday, and I think anybody could have told her that. She wants Corey Brown to testify what his actions were in his investigation, and mostly what they're talking about are the rods that they're using that go through the shirt and the mannequin that show the path of the bullet. She's not able to get expert testimony, and Attorney Hans has argued that the expert testimony has not revealed a path of a bullet and stuff, so he's saying that Corey Brown can't do it if an expert can't do it. Judge Aniga asked Marlissa Ferrer if she intends to use the rods for the trajectory of the path of the bullet, and the DA says yes. And Judge Aniga is looking very confused. She gets that look on her face that she gets when she hears something that she doesn't like, especially out of the DA. Marlissa Ferrer said that this is verifiable through other witnesses like Robert Woody, what he saw in the outwall standing over the victim. Attorney Hans argued that Robert Woody said that he turned around and then he heard the gunshot. He did not see what happened at the time of the shooting. He just heard the gunshot. And the DA, Marlissa Ferrer, has never said there is a execution type testimony. There is no trajectory evidence or reports from the experts, and he's saying that he opposes any attempt to get Corey Brown to bring that in. He says the expert can't do it or get specific about it. This witness can't do it either because he is not an expert in that field. It would be misguiding to the juror. He said he looked at the rods and the holes in the jacket and in the mannequin, and they can be manipulated, extremely manipulated, and whatever they want them to show can be done. It's not appropriate, as an expert can't make that conclusion, so Corey Brown cannot either. Marlissa Ferrer also argued that Robert Woody said the victim was on the ground, or they were in a above position, and then also Victor Navarre says the outlaw said in the jailhouse where he's claiming they confessed to the crime that the victim was on the ground, according to what the outlaw said, or what Navarre says the outlaw said. She said that again. Attorney Hans is making an argument showing how holes can be manipulated and line up is the evidence. He's making an argument. Corey Brown should not be precluded from showing how the rod goes through the holes. Judge Aniga says they are conflating two things once again. The people, Marlissa Ferrer actually started interrupting the judge again. As soon as the judge finished two things again, conflating two things again, she started talking, and the judge shut her down and chastised her again, and she said she's getting tired of her doing that. She says, Judge Aniga says the issue is the rods right now. Marlissa Ferrer is basing Corey Brown's testimony on other testimony not heard yet in this hearing, and referring to Robert Woody and now Victor Navarre. Without an expert determining the path, the rods clearly infer to the jury of the path. As of now, the rods will be removed. People like to call. I don't know who that was. Probably a scammer. The rods will be removed as of right now, and it's possible to get the rods in later after some witnesses' testimony in regards to the shooting, some experts or whatever. It would be speculation on the jury's part at this point. So they moved on to the mistrial motion. The judge is going to make a ruling. She wasn't taking any more argument in this thing, and she said going to the pretrial motion and the Brady disclosure or lack of disclosure that the defense is saying, and she's read a lot of case law. She went a long ways with this one. And basically she said that the district attorney's office or the prosecution has an obligation to turn over any type of discovery, how little or how large it may be, in regards to they cannot make that determination whether it's of value or not. They are obligated to turn it over. It could be exculpatory. It could be whatever. The district attorney is not, the people are not allowed to make that determinations. They are obligated under the law to turn it over. She gave a lot of citations on this and was quoting Justice Simon's book that she goes by. And then she reviewed what happened. On the 21st, Marlissa Ferrero wanted to check that angle tool on Google Maps in her office with Jim Cook. Was unable to do so. Jim Cook went home, or wherever he went, sent her the two maps that he sent her on the 21st of August. Shows that the property was outside of the cell sector that they kept saying that the Frank Carson property was in. The defense's argument that they would have been able to better cross and had more impact with the jury, she said that is pure speculation, as they really don't know, as they got to cross-examine him anyway. The issue is Jim Cook had made another of many mistakes. Jim Cook on the stand was on the stand 11 days, and it was obvious there was an issue with the Frank Carson property right from the start. She wanted located right from the start. The problem of whether it was in that sector of that tower, in that sector, or not. Jim Cook showed mistakes, was shown mistakes of other angles, and he was not correct. And especially, she noted the Highway 120 cell tower where he was 23 degrees off. She noted that she saw the look on Marlissa Ferrer's face when that happened, and it was not obvious that Marlissa Ferrer was not happy. He was caught, and it was not accurate. Jim Cook is a difficult witness. He cannot answer a question to save his soul, quote unquote. Cannot answer a question to save his soul. She has had other experts testify over the years many times, and she says they typically cannot stop talking. That's exactly what Jim Cook was doing, and he tried to moderate everything. There was an effective cross, and he was impeached many times. He has a time not shown. His actions have not shown, but the jury, I'm sorry, I read that wrong. His actions were shown very clearly to the jury, and prior to the mapping, the issue of the Frank Carson property was critical. Marlissa Ferrer became aware of Jim Cook's Google mappings on the 21st, and said she felt that it had no importance and just ignored it. But to Brady, it had to be disclosed as a potential problem. It had to be disclosed. She repeated that twice. There was no other alternative there. Prosecutors do not get to determine the importance of Brady information. It must be turned over. The defense questions that she sustained, and the objections that she sustained, were all improper and argumentative when Jim Cook retook the stand the next day. Was the evidence suppressed? She says no, it was not suppressed. The jury has heard the information, and the jury easily can see that Jim Cook has made serious mistakes. So the defense saying that it's more impactful if they had known earlier has not been proven, and she doesn't feel that's the case. The defense did have opportunity to use the information and put it in front of the jury. The information was Brady and favorable to the defense. It was not suppressed. There's no prejudice to the defense. The jury got the information. Jim Cook had just got to show that another mistake that he had made. Jago had brought up the 1054 sections. Those are evidence sections that he's talking about, where they have to immediately turn over information. Regardless of the information, it must be turned over. She said there's no prejudice to the defense, but she will give the jury instruction on that the prosecutor did not turn over the information to defense. So she's going to tell the jury the prosecutor failed to turn over some exculpatory evidence. And this is probably about, other than a mistrial, this is about the best that they're going to get out of this judge. Now, they have a lot of things going on. There's some more motion dates being set up. They talked about some of these dates and other issues going on. I don't know exactly what they're talking about. Sometimes they're talking in another language when they start talking about some things. And then they talked about Exhibit 550. It's a photo where there's some evidence was found. The DA, Marlissa Ferrer, says it's where the objects were in relationship to each other. Remember, Cherie Hendricks was pointing out where she found these things because she didn't mark the evidence at the scene when the body was recovered, and the Stanislaus sheriffs got up there 2 days later, and so she was pointing out where things were, so it couldn't possibly be in the exact location. So they did draw a diagram, but also it's not to scale. Percy Martinez says it does not accurately show where all items are. It's unknown where they were anyway. They just don't know. There's no diagrams or pictures or anything done by Cherie Hendricks from the start. It's it's misleading and suggests that there is a relationship to some of the items where there may not be, or vice versa. Jai Gohil argued somehow this shows the remains that were recovered by Cherie Hendricks, and it's an issue if they were found under jeans, if the bullet was found under the jeans or the jacket. They had all these problems in cross-examination. It was questionable where the bullet was, because Cherie Hendricks wrote in a report as one place, but insisted in testimony it was another. Now the DA is trying to show a diagram that is not accurate. It's just guesswork on where things were, and it's not to scale. So they didn't do any real measurements or do anything to show that the relationship to all the items to each other. Marlissa Ferrer said a diagram does not need to be scaled to get an accurate picture of where the things were. It is relevant information. Corey Brown can say and confirm the location and diagrams. He can confirm everything that's in this photo. Percy Martinez says the diagram is no different than a police report. The police report is not evidence. It's the officer's testimony that is evidence, and it can be referred to remind himself, but it's not evidence in itself. Judge Zuniga says Marlissa Ferrera's references to the photograph and the diagram, and it's not a photo that apparently that Corey Brown had made or marked or something. He didn't do any markings on it or something. She said to them, in effect, I didn't really catch everything she says sometimes. She says it's misleading. It's not to scale. This is Corey Brown's interpretation to where the items were. And the defense objection is sustained, so that particular item is not going to be allowed to be used. They went on to talk about the CD that Corey Brown had received from Apple, the Apple iCloud, and there was a couple of pictures of Frank Carson holding a bullet and things like that. They're going to allow the pictures, but not the CD itself, because there's a lot of other information on the CD that is not applicable and could even be prejudicial. So all they want to do is, the judge is not going to allow the CD to be entered into evidence or seen by the jury, just the picture itself. We took a break, and then when we came back, the jury was supposed to be brought up, but the judge was asking Marlissa Ferrer what Jack Abel and Gary Amoyan did at the Pop Cork the day that Corey Brown went over there and talked to them. Marlissa Ferrer is saying that those private investigators, Amoyan and Abel, had entered a contract with Frank Carson. And they said that they were trying to find out what you guys, meaning Corey Brown, have been talking, what they have gathered and trying to get together what they've been doing. Jack Abel said there's out-of-county judge has signed an affidavit. He says that says something in itself right there. And Jack Abel asked if they found Corey Kaufman's cell phone. She said it was suspicious that they kept talking about Corey Kaufman's cell phone. Marlissa Ferrer also said that Gary Amoyan also asked about the pinging of Corey Kaufman's phone and information in regard to that. And of course, Corey Brown's not going to tell him anything. And she said he also made a comment that the phone, Amoyan made a comment that the phone's battery would be dead by now. Percy Martinez argued all questions asked by the private investigators are simple, generic, basic questions that any private investigator, anybody investigating would ask. He says it's obvious that they're not co-conspirators in this thing. Jai Gohill argued, based on Marlissa Ferrera's comments, the private investigators said they were using just basic information from their past experience, and the contracts that they signed with Frank Carson have nothing to do, do not indicate with Frank Carson having to do with the actions of these investigators. It does not necessarily mean it was done at the bidding of Frank Carson. Marlissa Ferrer said Jack Abel also said he won't answer questions without it being in writing, so it shows working under Frank Carson. And they will not talk to Frank Navarro, or they also said that Frank Carson would not talk to Frank Navarro. Judge Aniga is saying that she has heard having a hard time with this. The party statements come in through examinations, cross-examinations, what have you, in the separate party. What she's saying is, I wrote it down, it's kind of confusing the way I wrote it down, but what she's saying is, these are separate party statements. It's hearsay. Corey Brown cannot testify to what they said. Now, these guys are not, up to this point, are going to plead the Fifth Amendment because they've been accused of being co-conspirators, as it seems like everybody else in the county is a co-conspirator in this thing too. And so Corey Brown cannot testify to what somebody else said because that's 115 testimony. It's only allowed in preliminary hearings. It's not allowed in trials. She said it's not that simple to say that they're agents of Frank Carson. She knows that Marlissa Ferrer wants it to come in for state of mind, but it's a due process issue, and she's simply not going to allow it. Marlissa Ferrer says, well, maybe we can decide on Tuesday when Jack Abel is supposed to come into court Tuesday. He's got to officially take the 5th or whatever. I don't know. And so she said, let's wait until Tuesday. The judge says that's fine. We can wait until for the final determination on Tuesdays, but it's not looking good for the people right now. They're way behind on this one. The jury was finally called up. They were in the courtroom about 11:12 a.m., so we had about 46 minutes of testimony in front of the jury. Percy Martinez was doing the cross on Corey Brown, and he asked him who assigned him to the case. It was Sergeant Kiley, his supervisor. Apparently Kiley and Sergeant Beharin at the time worked in the same unit, crimes against persons unit, just different units. He said he does not recall talking to Beharin to get information about the case. He was asked if Sergeant Kelly said anything about the DA's office having any interest in this case. There was an objection to that. In fact, there was 4 questions that were objected to very quickly. So that really never came out. He said he was told about a missing persons case that was already reported and wanted to have, and they brought him on to write affidavits for search warrants and wiretaps. He was aware of some of the other officers involved, like Kurt Bunch, John Evers, Frank Navarro, and Ken Behringer, that were members of this task force. And he was brought on to write search warrants for the task force for the wiretaps. He was asked if he gave any assignments out to the task force people. He said there were briefings that to determine who would do what, but there was really nobody assigned. It was just kind of agreed upon, is the way he made it sound. It sounded like he was making it sound like there was nobody in charge. Corey Brown said he did not direct Kurt Bunch to interview Mike Coley or anybody else. That was something that Kurt Bunch took on himself. And in May of 2012, they started doing, I think he said it was at the end of May or early June, that they started doing briefings at Ceres Police Department. He did not recall if he stored any evidence that was taken in anything at Ceres Police Department. It was all taken to the Sheriff's Department. In 2013, he had a meeting at the DA's office. He was asked if he had a meeting at the DA's office, and he said no. They were still at Ceres Police Department doing the briefings. He was asked in 2013 if Frank Carson was a target of any of the affidavits he was writing for search warrants or anything else, and he said he was not. He did go to the DA's office in 2015, in fact had his own office, and there was a briefing room that he had heard that was called the War Room. Corey Brown would see some of the bills that came through and some of the paperwork that was on the funding that they had asked for. And mostly it involved the Department of Justice and the CDCR. The DOJ involved the wiretaps. They were the ones really involved in the wiretap. CDCR was the high crime tech unit, things like that. In 2012, Corey Brown was assigned to the Ceres wiretap rooms, and the Sheriff's Office paid for it. The wiretaps are done through Ceres Police Department. They have the facilities apparently there for, and it sounds like any wiretaps that are done in the county are done at Ceres. There were briefings at the Sheriff's Office, but not with the task force. He says it was mostly just supervisors to fill them in and to give further guidance and or money or what have you. He was asked if at the Ceres Police Department if there was at the DA's office person was there at the wiretaps at Ceres Police Department. He said yes, there always was a DA person. The task force supervisor supervision. He was asked about supervision from the district attorney's office, and all he said was that there seemed to be no supervision or direction given to the DA's office. There's just that Ceres PD was Kurt Bunch, John Evers, and Frank Navarro. He never saw a district attorney supervisor there. He was asked about Derek Perry, and he said he was there at some briefings, he believed in 2013. but he never saw any funding that was requested or approved for Derek Perry. He talked about in August of 2013 they had gone to Mariposa, and it was actually on August 22nd, 2013. They'd been called, I believe, it was on the 22nd they were called, and they went to the scene. They also went to talk to Cherie Hendricks prior to going there, and said to Corey Coffin, he was asked if he had said something about Corey Coffin being in the area just prior to that, and he didn't. He said he didn't tell her Corey was there, but said somebody else said that they had cell tower information that somebody was there that was related to this somehow. He never got specific about it, and it was never asked about. But he did say they had already obtained cell phone records for Corey Coffin at that time. He went to the site, and Cherie Hendricks walked him around. He did note that there was no evidence tags, no markings, the scene wasn't secure or anything. He was also told at that date that Cherie Hendricks had made 2 trips to the scene looking for evidence, and then they drove from the scene. They were there about 5 hours back to Stanislaus County. Says they came through, he was asked a route that he took. He says he came through, well, he believes it was through 132, which he came through LaGrange and into Modesto. It was about an hour and a half trip. On 8/23 of 2013, he went back to the scene with Cherie Hendricks. She had no diagram, no notes, nothing marked, and she would just walk around and point to where she found things. On the first day that she went there, she had shown Corey Brown a picture of a .22 caliber. Now, Corey Brown was shown a picture of this .22 caliber, but this is the unspent round. And there was a ring and a nickel in this picture. And at the scene, Cherie Hendricks had pointed to where she had found these items. Corey Brown was not even aware that this unspent shell was in the package until he opened it. It was never mentioned to him prior to that. That's when he opened it, I think, back in Stanislaus County. But he never asked Cherie Hendricks where it came from. It was unknown where that bullet was found. This is an unspent. This is not the spent round. At the scene, he said he was at the scene for about 5 hours. And the soil in the area, it was a reddish brown. The top layer, he said, was reddish brown. The West Main address, talking about Frank Carson's dad's house, it was empty when they went to do the search warrant. Nothing had been taken there because the house was empty. And he said, he was asked if Valley Carson, Frank Carson's mom, she was there planting flowers and stuff. Was she doing anything suspicious? He said no, she wasn't. He was asked about the allegation of a body being buried in Turlock, and the description of the clothes that were worn by the victim, and if there's any request for testing done on the soil, on the clothes or the boots or anything, and test for the soil from the soil in Turlock compared to the soil in Mariposa. He says only the boots, but not the clothes, were tested for the soil samples. He also said he did not check the pockets or anything else to see if there is any soil or anything samples in the pockets of the clothes. And he was asked if there was any request for funding to the New York trip to interview Christine DiFilippo. He says, and he said no. There was also, he asked, was there a request for them to go to Las Vegas? He says no. He says also Hawaii and Australia. No, he wasn't aware of those requests for funding. He was asked about his 6-month leave from the sheriff's office. At the time that he took the leave, he was writing warrants for wiretaps. In 2015, he went back. He was asked by his supervisor to go back and start writing the affidavits for wiretaps and search warrants. So for some reason, he left for a while and came back in 2014. He was gone for 6 months. Percy Martinez took him the evidence of, I believe it was 551, with the box that had the boots and the other, the tongue and the insert and stuff that were in the box. He said he examined the right boot, but noted the discoloration as a reddish brown. He did have it examined. He did again in 2015, and they were tested for the presence of blood. All the items actually were tested for the presence of blood. And he also noted, including the insert that had the discoloration, several colors that were tested for blood, as there was a white, and he said that was a result of mold, and the brownish is the top layer of the soil in Mariposa. Also, the left boot was done the same. They wanted the inside and the outside of all the items tested for blood. At this time, we broke for lunch. The jury was out at right at the stroke of noon, and coming back at 1:30. Don't forget the podcast tonight, and let me know what you think about this new format of doing the reports.